great educationist who was speaking about the tussle over what should be the language. So if you remember, we don't have a national language, we have an official language. And there is still that tussle going on. So this is 1949, today we are in 2023. And you will realize that how some of these issues still are matters for debate. The second speaker was, of course, Pandit Nehru. The third speaker was Baba Saheb Ambedkar. The fourth speaker was Sardar Patel, who pointed out about enforceability of rights. Again, an issue that's still alive. The fifth speaker, many of you may not be aware, was Purnima Banerjee. And for today's topic, what she says there is very relevant when she asks the assembly not to vote upon God. This is because Mr. M.V. Kamath, who spoke immediately after her, wanted to actually table an amendment which said, in the name of God, we the people. So he wanted to start the whole reading of the Constitution in the preamble with the words in the name of God, and faced resistance from members of the Constituent Assembly only because they felt that is not something that they should be voting upon. But it also underscored the anxiety of the members of the Constituent Assembly that they should affirm secularism as a principle in the Constitution. The next speaker you heard was Alladi Krishnaswamy Iyer, a senior lawyer from Madras who was one of the guiding forces in the subcommittee on fundamental rights and minority rights. And he believes that they struck the compromise and adequately protected minority rights. In fact, as part of the part 3 of the Indian Constitution, you have a whole series of rights beginning with Article 25 up to Article 30, which addresses the concerns of the minorities, and not just religious minorities, but also linguistic minorities. The last speaker was Babu Rajendra Prasad, presiding over the Constituent Assembly, who then later on became the first president of India. And ironically, he invokes the name of God to thank for the success of the Constituent Assembly. So you could already see the tensions of the Constituent Assembly as to what is the position they need to take as far as the concept of God is concerned, whether they should foreground God as a concept in making the Constitution, as Pakistan has done when it foregrounds the salutations to Allah in the Constitution itself. Later, this was looked upon very carefully by the Indian Supreme Court, and this was seen as underscoring the fact that India is not a theocratic state. India could easily have proclaimed itself to be a Hindu nation. But there was a conscious choice made by the constitution makers, acknowledging the diversity and plurality of India, that it will not go down that route of becoming a theocratic state. Much more needs to be spoken about this, and I'll quote the words of the Supreme Court itself on this. But what is therefore important to note is that this was very much in the minds of the constitution makers when they debated these issues at the time of making of the Constitution. One of the members of the Constituent Assembly was K.T. Shah, who belonged to the Indian Socialist Party. In fact, again, for those who may not be aware, it is not that the Constituent Assembly members all came from just the Congress Party of that time. They came from diverse fields. And they supposedly represented several interests whose concerns needed to be addressed. So K.T. Shah tried to table an amendment to include the word secular in Article 1 of the Constitution itself. And he wanted to include these words, secular, socialist, federal. Now that amendment in 1949 was opposed. Why Shah wanted the amendment, in his own words, was this, and I quote him: "The secularity of the state must be stressed in view not only of the unhappy experiences we have had last year," and he's referring to the partition, "and in the years before, and the excess to which, in the name of religion, communalism or sectarianism can go, but I intend also to emphasize by this description the character and nature of the state which we are constituting today, which would ensure to all its peoples, all its citizens, and that in all matters relating to the governance of the country and dealings between man and man, dealings between citizen and government, the consideration that will actuate will be the objective realities of the situation, the material factors that condition our being, are living, and are acting. For that purpose and in that connection, no extraneous considerations of authority will be allowed to interfere, so that the relations between man and relation of citizen to state, relations of states inter se, may not be influenced by those other considerations which will result in injustice or inequality as between several citizens that constitute the people of India. So as I was saying, he wanted insertion of secular and socialist in Article 1, Sub-Article 1. And Baba Saheb Ambedkar, in rejecting that request, somehow did not refer to the word secular at all, but only the word socialist. And this is what he said. If you state in the Constitution that the social organization of the state shall take a particular form, you are, in my judgment, taking away the liberty of the people to decide what should be the social organization in which they wish to live. It is perfectly possible today for a majority of people to hold that the socialist organization of society is better than the capitalist organization of society. But it would be perfectly possible for thinking people to devise some other form of social organization which might be better than the socialist organization of today or tomorrow. I do not see, therefore, why the Constitution should tie down people to live in a particular form and not leave it to the people themselves to decide for themselves. So this really addressed the demand for insertion of the word socialist and not so much the demand for insertion of the word secular. As a result, in fact, there were two other amendments moved by others for including secularism in the Constitution in 1949 itself, which the Constituent Assembly did not agree. And as a result, you find today in the Constitution reference to the word secular, apart from in the preamble, which came about only in 1976 through the 42nd Amendment. You find a reference only in Article 25, Sub-Article 2, Clause A. So 25 talks of freedom of conscience and free profession, practice and propagation of religion. And 25.2 reads, and I quote, "Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice." So this is the only place in the entire Constitution, apart from the preamble, where the word secular occurs. And even in the preamble, it came at a time of the emergency and for purely political reasons, which readers of history will be aware of, students of political science will be aware of, but which I need not dwell upon too much at this stage. The word secularism otherwise permeates the whole of chapter 3. When we take Article 14, Article 15, and of course the Articles 25 to 30, there can be no mistaking that there was understanding of what constituted a purely religious activity and what could constitute as a secular activity. The equality of law and equal protection of the law that has been used to justify, for instance, the Shaira Banu judgment, where triple talaq was struck down by the Supreme Court on the anvil of Article 14, because Article 14 is seen to be the secular provision in the Constitution. Likewise, taking over of Hindu religious institutions through enactments, where you've had a whole series of enactments of taking over the running of temples, the Vaishnava Devi temple, for instance, in Jammu, that is governed by a statute. The Waqf Act, which takes over the running of Muslim institutions, because these activities of administration, dealing with finances, distribution of work, all of this which an institution might perform is seen as in the realm of being a secular activity and protected by Article 25(2)(a). It gives the power to the state to make a law to restrict any economic, financial, political or other secular activity that may be associated with religious practice. But as I will come to it later, there is a backlash against this in the recent past, where questions have been raised as to why state governments should be given the power to run religious institutions if we are a truly secular country. And that brings us the question about what is the Indian nature of secularism. Secularism has many forms. Under the American Constitution, it connotes strict separation of the state from religion. Neither state can interfere in religious affairs, nor will religion be allowed to interfere in state affairs. A wall of separation exists between religion and state as far as the United States is concerned. And this is despite the fact that many US presidents or presidential candidates have to demonstrate that they're God-fearing, that they go to the church, that they have a family. All these become very important parameters for the voters to decide. On a lighter tone, many male US presidential candidates will not be seen wearing spectacles. So that is one of those facts that they have there. But the point I'm making is this. The American version of secularism is something that we did not follow and cannot follow for reasons that I will speak about. The French notion of secularism is that the government can interfere in religious affairs, but not vice versa. Therefore, the display of religious symbols. France is very particular that hijab should not be worn. Although hijab is simply a headgear and should not offend anyone at all, but in France, they make a fetish that we will not permit wearing of hijab in schools. That was the French notion of secularism. The Indian notion of secularism, as understood by the judgments of the Supreme Court, is one of tolerance of all religions. But there has been a more nuanced understanding of this. I'll come to that in a minute. So the earliest attempted definition of secularism was in a judgment which the Supreme Court delivered in the context of challenge to the power of the Muslim minority denomination to excommunicate its members. So one of the first articulations of this was by Justice Rajagopal Iyengar, and this is what he had said while interpreting Articles 25 and 26, and I quote this. Articles 25 and 26 embody the principles of religious toleration that has been characteristic feature of the Indian civilization from the start of history. The instances and periods when this feature was absent being merely temporary aberrations. Besides, they serve to emphasize the secular nature of Indian democracy, which the founding fathers considered to be the very basis of the Constitution. If you see readings of Indian history, you will find that from the time of Emperor Ashoka, where he used the hyphenated term Brahmanas and Shamanas, and he said we should, and Ashoka, as you know, was one of the major propagationists of Buddhism. But Ashokan edicts tell us this principle of tolerance, of live and let live, and this has been quoted in several judgments of the Supreme Court, only to emphasize that the Indian version of secularism is different from the European or American notion of secularism. Then we have, of course, the Keshavananda Bharati case, where secularism is identified as one of the basic features of the Constitution, which cannot be amended away by Parliament. So the Parliament's power of amendment under Article 368 is curtailed by this notion of basic structure, and the amendment power is therefore hedged in, and that is what is now being questioned. So you will know why that question is now arising, because the Parliament wants, in a sense, to regain its power to amend the Constitution, even to take away its basic features, of which even secularism is one. In St. Xavier's, Ahmedabad St. Xavier's College, Society versus State of Gujarat, this was a judgment of 9 judges, which was delivered in the year 1973, 1974. 2 of the judges, Justices Matthew and Justice Chandrachud Senior, this is what they had said. The Constitution has not erected a rigid wall of separation between the church and the state. It is only in a qualified sense that India can be said to be a secular state. There are provisions in the Constitution which make one hesitate to characterize a state as secular. Secularism in the context of our constitution means only an attitude of live and let live, developing into an attitude of live and help live. Then we have the case of Ziauddin Burhanuddin Bukhari, where the Supreme Court went on to define secularism in the realm of philosophy and in utilitarian terms. That was an election dispute where seeking votes in the name of religion was decried, and the election was invalidated on that ground. The candidate said, I am the true Muslim and you should give votes to me and not to my opposing candidate who is not a true Muslim. And that was seen as inciting religious hate. Then we have the expanded notion of secularism in the Indira Sahni case. In the Indira Sahni case, which was in the wake of the Mandal amendments, where the central government of the day, based on the Mandal report, reserved 27% of jobs, government jobs, for other backward classes. The challenge was raised in the Supreme Court. Mr. Palkiwala was arguing for the petitioner, and in upholding those reservations, but saying that it will not be beyond a certain period of time, the Supreme Court also carved out what is called the creamy layer test to test the validity of reservations. Justice Kuldeep Singh, in that judgment, stated that secularism envisages a cohesive, unified, and casteless society. And Kuldeep Singh's opinion states, and I quote, caste poses a serious threat to secularism and as a consequence to the integrity of the country. So the Supreme Court is now enlarging the concept of secularism and recognizing that the caste distinctions that we've made, which Dr. Ambedkar recognized very early on, can be a serious threat to the integrity of the country, and therefore secularism had to be seen also in the terms of caste. Then we have the Bombay judgment. S.R. Bombay, as you know, that BJP ruled governments in the wake of the Babri Masjid demolition were dismissed by the central government of the day. And the Supreme Court upheld those dismissals. Of course, they built in a lot of precautions, saying that the proclamation had to be placed before Parliament and voted upon and cannot continue indefinitely, the President's rule proclamation. But in that process, there was a talk of secularism. This time, again, the Supreme Court reaffirmed that secularism is part of the basic structure of the Constitution. And Justice K. Ramaswamy, who came from the Andhra Pradesh High Court to the Supreme Court, the undivided Andhra Pradesh High Court to the Supreme Court, explained that programs or principles evolved by political parties based on religion amount to recognizing religion as part of the political governance, which the Constitution expressly prohibited. Basically, what Justice Ramaswamy is trying to say is, in public affairs, keep religion out. And now you can see how that is all being seriously challenged. In our public discourse, we find chief ministers donating monies to temples and making sure that it is public. We have political personalities associating themselves with yajnas, yagas, all religious functions. These are being official functions of governments which endorse a particular religion. So we have traveled a long way because of the political climate of the day, which raises a serious challenge to this understanding of secularism. Justice Ramaswamy says it is the duty of the court to bring every errant political party in line if it goes against the secular ideals like casteism and religious antagonisms. So in that process, both Justice Jeevan Reddy and Justice Suresh Agarwal, who were part of the bench in Bombay, they agreed with Justice Ramaswamy and went on to underline that the concept of secularism in the Indian Constitution is in agreement with the US Constitution's First Amendment. So two of the judges seem to endorse this wall of separation between the state and religion, which is not quite true. And as we will see that the balance is restored, but in an extreme way, in the subsequent judgments that came in Ismail Faruqi versus Union of India. Ismail Faruqi, you will understand, is the judgment delivered by the Supreme Court by a majority of 3:2, upholding the validity of the acquisition of certain properties in Ayodhya Act. The central government took over the property in which the Babri Masjid was located and where the temporary structure came up in wake of the demolition. And the question was about the validity of that statute itself. And there, the Supreme Court went into the question of what is an essential religious practice. They said praying in a particular place is not a fundamental right of the minority community, and they can't insist that that is a fundamental right, and therefore upheld the statute itself. But that shifted, in some sense, the understanding of secularism, because in the majority judgment of Justice J.S. Verma, for himself, Justice Venkatachalaya, Chief Justice Venkatachalaya and Justice G.N. Ray, Justice Verma went on to quote from Yajurveda, Atharva Veda, Rig Veda to justify the concept of secularism. So you will find an odd thing happening here. You quote a religious scripture to justify secularism. And according to him, these scriptures talked about Sarva Dharma Sambhava, that is tolerance of all religions. So it was, in a sense, justifying secularism by religious scriptures. So the Bommai understanding of secularism was not adhered to, and the dissent, of course, while acknowledging that Hindus are the majority community, still believed that the Indian constitution has a different flavor of secularism which needs to be protected. In fact, in that context, I wanted to just refer to what what Babasaheb Ambedkar told the Constituent Assembly at the time of the final draft. He said, no minority in India has taken the stand that we don't want to be ruled by you. They have loyally accepted the rule of the majority, which is basically a communal majority and not a political majority. It is for the majority to realize its duty not to discriminate against the minorities. Whether the minorities will continue or will vanish must depend on this habit of the majority. The moment the majority loses the habit of discriminating against the minorities can have no ground to exist. Again, Dr. Ambedkar is prophetic. He apprehends very rightly, and like he apprehended in that clip that you saw, that the absence of two things, which is equality and fraternity. He reminded us in 1949, and here he's talking of discrimination against the minorities and what the majority is expected to do in a constitution and which encompasses rule of law. We then have the Hindutva judgments, as they are called, a triumvirate of judgments, Yashwant Prabhu versus Kunte, which is challenging of elections held in Maharashtra, where the Shiv Sena many leaders of Shiv Sena addressed public rallies, and one of those rallies, they actually said, we want to establish a Hindu rule in Maharashtra. So Justice Verma, in commenting on that, he said the leaders should be more circumspect and careful in the kind of language they use, and stated that the statement that the first Hindu state will be established in Maharashtra is by itself not an appeal for votes on religious grounds, but the expression at best of such hope. And Justice Verma then went on to equate Hinduism, Hindutva, and Indianization. And this is what he said, I'll quote, "The words Hinduism or Hindutva are not necessary to be understood and construed narrowly, confined only to the strict Hindu religious practices, unrelated to culture and ethos of the people of India, depicting the way of the life of the Indian people." So again, in a series of cases, they tried to explain that there was no inherent contradiction between the nature of secularism that was explained in Bommai to these judgments, the Hindutva judgments, where they're basically saying that secularism is even part of the religious scriptures, like Rig Veda, Yajur Veda, and Atharva Veda. What this has also brought up is the role of the court. Unlike other jurisdictions, the Indian courts seem to take upon themselves the task of determining what can be strictly a religious activity and what is a secular activity. Very often you've had religious groups whose activities are sought to be controlled by the state, whose secular activities are sought to be controlled by the state, going to the court and saying, our essential religious practice is being affected. For instance, you'll have the Anand Margis going to the court and saying that Tandava dance is an essential religious practice for us, and we should be allowed to perform the Tandava dance in public. The Supreme Court went as far as saying that, okay, even if we, for a minute, accept that the Tandava dance is an essential religious practice for the Anand Margis, performing it in the public might give rise to law and order because they're supposed to carry spears and other weapons when they perform the dance, and therefore we will not allow it to be performed in public. You had the Ramakrishna Math going with the Supreme Court and saying that we are a different religious denomination and not strictly a Hindu denomination, and therefore we should not be controlled by the government. That is an argument which was accepted by the Calcutta High Court but rejected by the Supreme Court in a judgment. Then we've had the Shirur Math case of 1954, where the first attempt was made as identifying what is a strictly religious practice, essential religious practice, and what is not. Then we have the Dargah Committee case, where again the court said, speaking through Justice Gajendra Gadkar, that the court will have to be very careful in not accepting any and every practice as an essential religious practice. If I may just quote that, and that is relevant for what I'm going to now say. I'll come to that in a minute. What has happened is this distinction that the court makes between essential religious practice and a secular practice has become the bone of contention in the Sabarimala case. The question in the Sabarimala case was trying to amend through regulations the entry of women between the ages of 10 and 55 in the Ayyappa temple. That was challenged, and one of the grounds of challenge was, of course, a technical challenge, saying that the Act itself does not have such a restriction. How can you introduce it through regulations? So the majority, which is 4:1, agree that you can't do it through regulations and strike down that regulation. But the majority goes on to find whether it's essential tenet of that particular practice that women are kept out. And Justice Chandrachud, the present Chief Justice, evolves what is called an anti-exclusion test. He says the preamble itself foregrounds individual dignity, and therefore the dignity of women is seriously affected if they are going to be treated as untouchables, and that is abhorrent to human dignity and to Article 17 of the Constitution, and therefore this very regulation must fail on that ground as well. Now what it has happened as an aftermath of Sabarimala is very interesting. Although 5 judges by a majority 4:1 permitted entry of women between the ages of 10 and 55 in the Sabarimala temple, within a few months a different composition of the bench admitted, with one of the changes being the presiding judge, admitted what is called a review petition, with again a dissent of 2 of the members of the Constitution bench, Justice Rohinton Nariman and Justice Chandrachud. So the split majority of 3:2 admitted the review petition. A further petition was filed questioning whether this could be done in the same case by a subsequent 5-judge bench, and the 9-judge bench upheld this admitting of the review petition. The review petition has been admitted on this very ground of essential religious practice, whether the court can take on this exercise or should leave it to the religion itself to determine, the religious denomination itself to determine what is its essential religious practice. So this is a question that is still at large. It hopefully will get settled sometime soon. Right now, therefore, the Sabarimala judgment also, although it is a 4:1 judgment, is not yet the law of the land. It has been put in hibernation. I could go on and on secularism and the Supreme Court. Basically, what we need to understand is the judge's understanding of secularism is through texts themselves, commentaries themselves. whether it's Islamic law in the terms of triple talaq, or whether it's the Waqf Act which is being questioned, or in the Chidambaram Dikshidhar case, very recently Subramanian Swamy was the state of Tamil Nadu, where they said that the right of the Dikshidhars to perform, to take over the administration of the Chidambaram temple can't be taken away by the government. In fact, it was a victory for the Chidambaram Dikshidhars. Recently, you've had, just last week, the Supreme Court staying a measure by the Tamil Nadu government recognizing non-Brahmins as priests and women as priests. So this seems to be a lot of tension between what a government wishes to do, which is a popular government elected by the people, and what the Supreme Court views as an essential religious practice which cannot be trammeled upon by the state government. That tension continues to exist. But the point that I'm trying to make, like there's a judgment which goes by the name of Bal Patil versus Union of India, where Jains went to the court and said Jains should be treated as a religious minority. Now, although Jains are a religious minority in a sense, but you will notice under the Hindu code, whether it's the Hindu Marriage Act, the Hindu Succession Act, Jains and Sikhs are bracketed with Hindus. And a conscious decision was made to treat them as Hindus. Now, Jains want to assert that, no, we are a separate religious denomination and we must be recognized as a minority. But that was shot down in Bal Patil versus Union of India. And Justice D.M. Dharmadhikari, who is the judge who gave that judgment, says this: the country has already been reorganized in the year 1956 under the States Reorganization Act on the basis of language. Differential treatments to linguistic minorities based on language within the state is understandable. But if the same concept for minorities on the basis of religion is encouraged, the whole country, which is already under class and social conflicts due to various divisive forces, will further face division on the basis of religious diversities. Such claims to minority status based on religion would increase in the fond hope of various sections of people getting special protections, privileges, and treatment as part of the constitutional guarantee. Encouragement to such vociferous tendencies would be a serious jolt to the secular structure of constitutional democracy. We should guard against making our country akin to a theocratic state based on multinationalism. This is very important for us to understand in the context of secularism, and how we should not be encouraging further assertions of recognition as religious minorities and for getting privileges on that basis. This has been reiterated in the Coelho judgment, and before that in the Nagaraj judgment. And this concept of secularism, which was spelled out in 25 to 30, has been used by the Supreme Court to protect the right of the Jain minorities in Gujarat to have the sale of meat banned during their religious festivals. So this is the judgment in Hinsa Virodhak Sangh versus Mirzapur Moti Quresh Jamaat. You will understand when I say this, and this is on a lighter note, we had the Hanif Qureshi judgment, which permitted slaughter of milch cows, buffaloes, after an age of 14, when they had stopped producing milk. And this was a judgment of 1956. This Hanif Qureshi judgment, which was by 5 judges, stood reversed in state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, which is a 2005 judgment. And they used Article 48 to say there can be a complete ban on slaughter of cattle and not necessarily milk producing cows. Even bullocks, there could be a complete ban on slaughter of all such animals. And on a lighter note, the composition of that bench had 6 vegetarians and 1 non-vegetarian. And it was a non-vegetarian judge who wrote the dissent. So even composition of benches to deal with issues like this become important. There are several issues that I thought I should flag when we are discussing secularism. One is the changing nature of the polity, where I pointed out earlier, assertion of majoritarianism and of religious majority, and wanting the state to be shaped in the vision of that religious majority. This is a development that has taken place in the last 10 years, which we must acknowledge, which is what is giving rise to all these debates that we are having in the public domain. I think one important trigger for this was the Ayodhya judgment itself. For the first time, we had the Supreme Court issuing a mandamus to the central government regarding construction of a temple. So that was not even the prayer made in the suits, but this was a relief granted in the Supreme Court in the judgment, which is a unanimous judgment, that the government should take steps to build a temple at the disputed site. So what this does to the concept of secularism, when it's a judgment of the Supreme Court itself, is the question. Second is, which I mentioned earlier, this notion, that is the monarchic notion of the ruler of the country being the defender of the faith. So that whole notion that, in every important function concerning the state, there must be a religious basis for it. There must be a religious legitimation of it, like you saw in the inauguration of the parliament. So what that does, again, to this notion of secularism is something that we need to reflect on. Then we have the codifications of the Hindu code, which met with serious resistance. I think scholars of legal history will go back and see the pitched battles that were fought in the parliament and led to the resignation of Baba Saheb Ambedkar as a law minister from the very first cabinet, when the Hindu code came about, when the Hindu Marriage Act, Hindu Succession Act, and even now the amendments to the Hindu Succession Act, which recognizes the rights of women to co-parcenary property, to recognize as a co-partner and to co-parcenary property, that tells us the tensions, existing tensions between our understanding of the Hindu religion and what it permits and what it does not. But the expanded notion of secularism that the Supreme Court has brought about, which includes gender diversity. Sabarimala is an important recognition that in the name of a religious practice, you cannot discriminate against women. That needs to be debated about. It will be debated when the 9-judge bench, when the review bench revisits the whole notion, and also expanding it to make it plural and inclusive so that it deals with the issue of caste discrimination. Much of caste discrimination is coming through what we understand to be a religious practice. And at this stage, I want you to reflect on something that is very disturbing in our society, that caste discrimination is not confined to the Hindus. Those in the audience who may not be aware of it, I just want to remind you that this is something that we seem to have carried across religions in India. Whether it's the Muslims, whether it's the Sikhs, whether it's the other religious minorities, caste seems to be a supervening factor which determines all our actions, particularly choices of marriage. And within the Dalits, there is a caste hierarchy. So I want us to just see the small clip which comes from a documentary called India Untouched. This is there on YouTube. I want each of you to watch this documentary. It is called India Untouched. It's made more than 12 to 15 years ago. And it's done through interviews with actual people. It's not a fiction, it's actually a documentary, a non-fiction. So I just want to play that small clip.
में लिखा हुआ है।
अब हम शेख हैं तो शेखई में होगा, पैठान में नहीं हो सकता है, जोला में नहीं हो सकता है।
क्यों?
अपना ही में न होगा।
ये मुसलमानों में जो है
सबसे बड़ा जात है।
आपसे में रिश्ता करना है, शादी करना है, तो दिल का दिल के साथ होएगा, जट से कर सके।
क्यों?
I prefer so. I had a belief in one caste. I like to invite a man to my life who is from the same caste.
എനിക്കൊരു സവർണ്ണ ക്രിസ്ത്യാനിയെ കെട്ടാൻ പറ്റത്തില്ല കേരളത്തിൽ. ഒരു സാംബോക് ഹിന്ദുവിനെ കിട്ടിയാൽ, അല്ലെ ഒരു സാംബോക് ഹിന്ദുവിനെ കിട്ടുന്ന കേരളത്തിലൊരു ഇഷ്യൂവേ അല്ല. സാംബോക് ഹിന്ദു സാംബോ എന്ന് പറയുന്ന ഒരു അൺടച്ചബിൾ കാസ്റ്റാണ്. അവരെ കല്യാണം കഴിക്കുന്നതിന് കേരളത്തിൽ പ്രശ്നമില്ല. പക്ഷേ ഞാൻ ക്രിസ്ത്യാനിയാണെങ്കിൽ പോലും ഒരു കത്തോലിക്ക ക്രിസ്ത്യാനിയെ ഞാൻ കല്യാണം കഴിച്ചാൽ കേരളം ഇളകി മറിയും. സമ്മതിക്കില്ല അവർ.
ऐसे जो राधिका शादी के लिए होने के बाद प्यार से अथवा नागरिकता से पैसे से होने से नेक्स्ट जनरेशन उनका बेटा का भी शादी होना मुश्किल होता है, फिर अमेरिका जाता है, अमेरिका बेटी ही मिलता है, इंडियन बेटी मिलना बहुत मुश्किल होता है।
अब दूसरे
The world
there is some kind of caste and there is some kind of discrimination everywhere in the world.
But not based by birth.
All right, not based by birth. So why are you just against birth? You have a society which has just casteless and birth has got no meaning. You think that the father and son then have some resemblance. You deface the face of that son so that he doesn't look like his father.
कल को ये पैर कह दे करोड़ों वर्ष से हमारे ऊपर ये शरीर खड़ा है, हमको दलित कर दिया है इसने, अब हम ऊपर रहेंगे और सिर नीचे रहेगा। अब पता लगा कि स्टालिन सिर के बल पर चल रहा है, कहीं पागल हो गए क्या हो हैं?
So one of the commentators, Rajiv Bhargava, who's coming out of the book called Revisiting Secularism, Reimagining Secularism, says that caste is like the church in Europe. Caste itself becomes the major oppressor. So if you look at secularism purely from the angle of religion, you will not get a complete answer at all, because it's much more complex in the Indian scenario. He believes that we should therefore have our own answers instead of looking at the West as to how we should reassert Indian notion of secularism, which dates to an ancient past which included Ashoka. Interestingly, he talks of the early Vedic texts as not mentioning gods at all. So he says there can be a religion without gods in India. There was, at a particular point in Indian history, a religion without gods. So the religionalizing of India is something that he's questioning. And he's saying that we therefore need to go back and find answers through that path, where we had a much richer tradition of coexisting in different practices and beliefs, and even being atheistic. He refers to Charavaka, for instance. And this same Indian society accommodated all points of view and was able to find coexistence, peaceful harmony and coexistence side by side with the differing traditions. I could go on and on, but the point I think we need to make is this is the time to debate this notion of secularism. I know there can be several points of view on this, but we should remember that our constitution is our unifying factor. Our constitution is what we should abide by. Our constitution recognizes secularism as understood in the Indian ethos as part of the basic structure of the constitution. And our constitution is something we should believe in. It's important for law persons to believe in our own constitution. Of course, we can have a healthy debate on it. I'm sure there are lawyers who have a different point of view. I'm sure there are scholars who have a different point of view. But this must be a matter of debate. It must not lead to strife that leads to violence. That is unnecessary and not called for at all. I'm glad that All India Lawyers Union is providing a platform for this debate. I'm sure it should be a healthy debate, and it will lead to best practices in trying to resolve conflicts on much of these major issues. I think I've covered the whole gamut of what the Supreme Court says on secularism. If any of you have any questions, I'm prepared to take them. Thank you for your patient listening. Jai Hind.
Thank you, sir, for elaborating discussion on the secularism of with regard to our constitution. Thank you once again on behalf of All India Lawyers Union Telangana State Committee. ఎవరికైనా అడ్వకేట్స్కి ఏమైనా క్వశ్చన్స్ ఉంటాయి, మార్నింగ్ నుంచి ఇప్పుడు దాకా సెషన్ విన్నారు కదా, ఎవరికైనా ఏమైనా డౌట్ కానీ ఏమైనా క్వశ్చన్ కానీ ఉంటే పోజ్ చేయండి, సమాధానం చెప్పే అవకాశం ఉంది ఒక 5-10 నిమిషాలు. ఎవరికైనా డౌట్స్ ఉంటే చెప్పవలసిందిగా కోరుతా ఉన్నాం. నిర్వహించి కొన్ని ప్రైజెస్ ఇవ్వడం జరిగింది. మిగతా ప్రైజెస్ ఇప్పుడు మన చీఫ్ గెస్ట్ గారి ద్వారా ఇప్పించడానికి ప్రయత్నం చేస్తా ఉన్నాం. ఈ కాంపిటీషన్స్ నిర్వహించినటువంటి ఫాతిమా, ఐ రిక్వెస్ట్ కుమారి ఫాతిమా come on to the dais and announce the names.
I would like to invite Ms. MP Stalin to come and collect the certificate. Okay, and Karunakar, the second person. Then either Ali Haider, sorry. Come. This side, this side. Stalin, where he went, right? They're coming, like in a minute or 2 minutes. Okay. One more person was there. One more. Okay. There is one. One. Where is Karun? Karun. Where is Karun? इधर से हाँ give us the call MP Stalin let's see.
క్వశ్చన్స్ ఎవరైనా డౌట్స్ ఉన్న వాళ్ళకి కార్డ్లెస్ ఇది వస్తుంది మైక్ మీ దగ్గరికి. అక్కడి నుంచి క్వశ్చన్ అడిగితే ఇక్కడ సమాధానం చెప్పడానికి అవకాశం ఉంది. ఎవరికైనా అక్కడ సార్ అక్కడ అటు వెనక్కి ఇవ్వండి, వెనక్కి మైక్ కార్డ్లెస్ మైక్ మీ దగ్గరకు వస్తుంది. మీ ప్రశ్న అడగవలసిందిగా కోరుతున్నాం. దయచేసి అందరూ కూర్చోండి, ఒక 5-10 నిమిషాల్లో కార్యక్రమం అయిపోతుంది.
హలో, నమస్కారం సార్. సార్ నమస్కారం సార్. సార్, వీఆర్ హియరింగ్ అవర్ కంట్రీస్ నేమ్ ఈజ్ గోయింగ్ టు బి చేంజ్డ్ ఇన్ టు భారత్. సో ఈజ్ ఇట్ సెక్యులర్? మై డౌట్ ఈజ్, వాట్ ఈజ్ యువర్ ఒపీనియన్ ఆన్ ఇట్, సార్?
The word Bharat is already there in the constitution. It says India, that is Bharat. So I don't see this having any problem at all. It has nothing to do with secularism. There should be no problem at all.
Then why media is doing so much of fuss?
So what politicians do, politicians will do for political purposes.
So
let's as rational beings calmly and reflect on it and find that the constitution itself says India, that is Bharat.
Okay, Bharat is okay, sir.
Yes, of course.
Thank you, sir.
As long as India is not removed.
Okay, sir. Okay, thank you, sir. Thank you.
Sir, you have said about the government removing the distinction about religious functions, the executive conducting pujas and all. But in my personal I have seen in High Court even a Honorable Supreme Court judge being felicitated by Veda Pandits on the dais.
Correct.
So
Correct.
what do you say?
No,
At least
this
the
is
judiciary.
this is what we need to reflect on. See, the original notion of secularism was to keep away religion from official functions, not on private functions. I must share with all of you, can we have this recording stop?
Yeah.
See, there's a funny incident of the Hirakud Dam in 1958. Pandit Nehru was supposed to come and inaugurate the dam. We had a chief engineer who was a devout Vaishnavite. and he had fixed the function such a way that Pandit Nehru would first come, address the gathering, inaugurate the dam at 6 in the evening. This was because there was a Rahu Kal on that particular day.